Hello again, blogging heads. My name is Bill Beutler, and I'm back after a short time away. Every once in a while, Bob and the good people at Blogging Heads allow me to come on and talk about technological change and how tech policy is affected and how we as citizens and consumers and as people are affected. So joining me again for the first time is Simon Owens. I will let him introduce himself.
Well, I'm the director of digital content for Levick, a public affairs firm in DC, and I'm also a tech and media journalist. You can find my writing at simonowens.net.
Terrific. And then for viewers who haven't maybe seen me for a while, although I did kind of just say what I'm doing here, I used to appear on the forerunner of the DMZ back when it was called the Weekend Blog, back when the blogosphere really meant something, back when it had heart, which is another topic maybe for another time. But anyway, I'm the founder and president of a content marketing firm in DC called Beutler Inc. And in another case of being on the digital airwaves, I've also recently launched a podcast called Kubrickcast, going through the films of Stanley Kubrick one at a time. But today, we should probably get on topic here pretty quick. We're here to talk about the Aereo case, which is currently before the Supreme Court. So Simon, for viewers who are maybe not totally familiar with what that is, would you like to set the scene for us?
Sure. Aereo is a company. It's owned by AIC, which is owned by the billionaire Barry Diller. You might have seen him in the news for the disastrous purchase of Newsweek. But he actually, owns several very profitable internet companies in New York. And one of those companies is Aereo. And Aereo, the basic concept behind it is we have these public airwaves. We have, CBS, NBC, Fox, that are mandated to broadcast their airwaves for free using public spectrum. And it's anybody can access those airwaves using so-called bunny ears antenna. And the concept behind Aereo is that instead of broadcasting to those antenna going directly into your TV, it's broadcasting to antenna to stream through to your computer. But also at the same time, it's acting as a kind of cloud DVR service so that it's capturing those live streams of those public broadcasts and storing them in the cloud for you so that you could watch television on demand.
Mm-hmm. Well, and it's not just the one antenna that they're capturing it on. Kind of the call it gimmicky or call it innovative aspect of Aereo is that they have what they call, they have thousands apparently. They have thousands of dime-sized antenna. For as many customers as it has, that is how many antennas they have, right?
Right. And their business model, unlike the bunny ear analogy, where you just purchase the bunny ears and then you basically get all the free broadcasting you want. In this case, you quote unquote rent one of their antennas, and I think that's they purposefully make it so that you're renting rather than paying a subscription fee. Because as we'll probably get into, when you start talking about subscription fees, then you start sounding a lot like you're a cable company or something like Netflix or Amazon Prime.
Well, I'm wrong, but do they not call it a subscription? Because I do know it's
no. They very specifically say you are renting one of their antennas.
Okay, renting, sure.
So it's not like you're paying for the content, which they don't own. You're paying
right.
You're paying to use their antenna.
I'm not totally sure what the difference is between $8 a month subscription and $8 a month renting the equipment. But actually, that is
that's kind of the crux of the Supreme Court case is the broadcasters who are suing them would argue that there is no difference, and they would say, hey, we're just like they would compare themselves perhaps to a Roku, where they're saying we're just a technology company we're kind of the tubes that this content is going through. We have nothing to do with the content itself.
Right. Well, let's get to the Supreme Court aspect of this in just a little bit. I think it would be helpful to talk a little bit about the business context of it and also the legal and regulatory background, all of which leads up to where the Supreme Court is at. Mm-hmm. So, there's a concept that figures into this really heavily and I've been following Aereo casually for a while before I really boned up on it for this. So retransmission fees are kind of the big reason that there is a fight going on. There's many reasons, but when through going back through the regulation and previous Supreme Court cases that have created the regulatory landscape of communications today. In the first place, there was just broadcast, radio, and then television, and then in the 60s and 70s, along came cable, and cable was able to just take take the signals from the airwaves and put them onto their cable systems. And so it was hammered out through a combination of Congress and courts to create this retransmission consent situation, whereby let me make sure I get this right. The broadcasters basically can charge. They kind of have to allow, but can charge money to the cable operators to carry their programming. Their programming is valuable, and the cable companies should compensate them for it. And so the fees that the cable pays to the networks, that's the retransmission fee. And basically, they just have to come to an agreement about it. They're required to negotiate in good faith. And, I did write this down. It's the Cable TV Consumer Protection and Competition Act. Got to be one of the worst. Yeah,
which was passed in 1992.
Oh, that's right. I mean, one of the worst named bills ever, but that's neither here nor there. And so that kind of set things up. And well, Aereo comes in and threatens that, because Aereo, it also is catching the signals out of the air, but it is not then. It's not paying for it, for one thing. Mm-hmm. And they're saying that they don't have to pay for it, because what they're doing is they are collecting it for free, the way that you or I would collect it for free. I guess what they would say is they're not the ones doing it. You are doing it. If you are a subscriber, I did it again. If you are renting and this is why their case is so difficult. I mean, just to spill the beans here, I think we both started out looking at this being fairly intrigued by and sympathetic to Aereo, but by the end of this, it was harder and harder to do. So, they would say that they captured the signal, and then you just, pull the signal through them, but everybody does it individually. And there's another concept in here that's really important. That is, what constitutes a public performance? Because if you go back to the 1909 Communications or Copyright Act, that's where they first started to define what was what constitutes public performance. It's okay for you to listen to the radio in your home, but it may not be okay to, open a pool hall and then charge people access to come listen to that. That's the very beginning of it. And over time, technology has complicated it.
Yeah, so obviously the opposite of public performance is private performance. So it's defined as private performance is that if you buy a DVD or a book, you own that piece of content, and you can pretty much use it within reason any way that you see fit. Mm-hmm. But the second that you start broadcasting it from any, like a movie theater or mm-hmm. A television in a bar or anything like that, where it's for public consumption, then that is public viewing, right. and is subject to licensing fees and permissions and all that. So they would argue that Aereo would argue that they are for private viewing, and the broadcasters are arguing that this is very mm-hmm. clearly for public consumption.
And I can totally see, and I still want to be sympathetic to the argument that if I am renting an antenna, a tiny antenna that's I guess up in New York, wherever they are, if I'm renting that, and the signal that comes through that goes only to me, and I'm the one who chooses what I watch out of that. And think about Aereo. We speak to the value of Aereo. You can send that TV through to your mobile devices. You can hit pause. You can record. So you can time shift programs. It's essentially like a DVR that you pay a lot less for. Mm-hmm. And because it's a little difficult for me mentally to get to this being a public performance if I just focus on myself. If I just focus on my experience as a consumer, it does feel like a private performance.
So
challenge, I think, is when you go for it. Yeah,
so I have a counter argument. So
go for it.
let's first start with what I think I would be more on Aereo's side if
Mm-hmm.
if things were slightly different. I would be totally behind what Aereo is doing if it were simply a technology offering in which it is offering to stream what appears on the public broadcast to my computer, so I can watch it just as if I were to turn on my TV and use antenna. What
Mm-hmm.
what they are doing is, one, they are basically creating on-demand services. So it's not necessarily has to be a live stream. They are doing it so I can record and call up a show, which is very similar to what companies that actually license content like Netflix and Amazon Prime and any kind of Comcast on demand are doing. That have to, for instance, Scandal, which is runs on a public broadcast network, is currently licensed by Netflix, and they have to pay a lot of money to be able to carry it in its offerings.
Mm-hmm.
And two, it's not just a piece of technology that you're paying once for, like the bunny ears. They are paying what they call renting. I would call a subscription fee that very much
Mm-hmm.
looks and sounds like the $8 a month I'm paying for Netflix, the $6 a month I'm paying for Amazon Prime.
Mm-hmm.
If I had cable, the cable subscription that I have. So they're charging for access to that content, and they're displaying it on demand.
Mm-hmm.
If they
Yeah,
were,
they're,
sorry.
There's really quickly. There's more to it than just the hardware.
Mm-hmm.
There's a whole software interface. There are apps for iPhone and iPad. So yeah, it's a service, right? It's got to be.
And let's talk about the ways that they seem to be kind of acknowledging that they're in a legal gray area. First, they don't call
Mm-hmm.
it subscription or fees or anything like that. They say that you're renting an antenna. So
Mm-hmm.
it's a very weird way to kind of position yourself of what the consumer is doing here. They're just renting the
Mm-hmm.
hardware. Nothing that they're doing has anything to do with the content itself. The second thing is what they're doing with the antennas themselves. Rather than having one very large antenna that they're sucking these airway. I'm going to get super non-technical here, but that they're pulling in all these public broadcasts through and then shuffling it out to all these computers. They have thousands and thousands of tiny antennas so that you can have a one-on-one relationship with the antenna. So it does seem like you're renting one antenna just for you. So it's not like they're pulling everything into one antenna and then broadcasting it out to 10,000. Each one of those 10,000 can rent their own antenna. So it seems like there's a one-to-one relationship. And from what I've read, there's no technological reason for this. They tried to argue that there is, but it's not like having 10,000 antennas is making it that much more efficient or is improving the quality of the broadcast at all. So it seems like that what they're doing is they're trying to find a loophole, in which case that they would be considered, private consumption rather than public.
So I would completely agree with your description of how that model is set up. I might take issue, and this might be just for devil's advocacy purposes, but I might take issue with the loophole part of that, because the setup of having all of those thousands of antenna is so that they comply with what the regulations say.
Mm-hmm.
And if it is a loophole, a loophole essentially is a value judgment being applied to a situation, right? And what they're doing apparently may be legal, and this is, of course, what the Supreme Court is going to determine. But they clearly have designed their service in such a way as to comply with the laws, as at least they are interpreting it, as they think is a plausible interpretation. And are you taking that negative value judgment when you say loophole?
Well, the loophole always has a slightly negative connotation, or a slightly sly one at least. And you're right. In order for a loophole to be a true loophole, it has to be, I think the definition, it would have to actually be legal. So we might not like it, or they might be getting away with a sleight of hand, but the fact is they're keeping it within the parameters. I guess the reason why it's a Supreme Court now is obviously that loophole isn't super clear cut, and so by trying to exploit a loophole, they're kind of showing basically showing their cards a little bit by showing how much they're trying to create a loophole that even they somewhat recognize that they are in a legal gray area. So if the case does come out on their side, then they have actually found a legitimate loophole, but they're also, I think, sending a signal to the justices, and this is something that the justices asked a lot of questions about, like why did you decide to have 10,000 antennas? That even the justices are suspicious of what their claims are in terms of being a company that is merely a technology company rather than a content distribution company.
Right. So I mean, before we get to the Supreme Court case, they're basically, like every time you go to the Supreme Court, it's been tried several times, or it's been, here's the deal. Actually, up to now, I want to say Dropbox for some reason. That will come up later. Aereo has been quite successful in the courts. They have won most of the cases that they are involved. So it is the broadcasters that are themselves the plaintiffs in this case. And so, I mean, their argument, if I can summarize their argument well enough, it's the loophole to evade paying the fees for sure. The fees which they claim are the lifeblood of the broadcasters. But as far as we know, it's about 10% of their fees.
Yeah, about 10% of their revenue. Yeah,
and the rest is mostly from advertising. It's not nothing. If I lost 10% of my income, I think I would have to eat out less often, and I might change my lifestyle a bit. It wouldn't fundamentally threaten me, but they definitely are saying that it's fundamentally threatening. Mm-hmm. And of course, we talked about before that they argue that what Aereo is doing constitutes a public performance. And in researching this, it's interesting. They have about a 2-to-1 amicus edge in terms of amicus briefs that are filed by outside parties. So in terms of those outside parties,
Aereo?
No. The broadcasters do. Okay. Yeah, and so here's where it's less surprising that the broadcasters, it's content companies, it's the Hollywood and music. They're on the broadcasters' side. The Justice Department also filed an amicus brief, and in fact they got 1/3. The Justice Department, I think, got 1/3 of the time to talk in front of the Supreme Court, making its case. That one, actually, I'm not totally sure about. I do know that the actual lead attorney for the plaintiffs got 2/3 of the time that they talked, and then I know that on Aereo's case, they had just their one counsel talking for 30 minutes.
And I know the EFF, the Electronic Frontier Foundation, they had an amicus brief on behalf of Aereo. I don't know who else.
Sounds right.
I don't know who else was in support of them.
It tends to be technology companies. It tends to be open source advocates. There's totally, if you were to transport the two sides from the net neutrality debate over to this, you would find them breaking down roughly it's content versus technology. So not a big surprise there based on what the topic is. And by the way, I think we should start getting toward the, when I was saying Dropbox, a little bit of a Freudian slip there about a big part of Aereo's argument is that they are concerned, certainly they say they're concerned, that if the Supreme Court shuts them down, that this could have a wider negative impact on other cloud computing companies and platforms. And so they position themselves as a cloud computing service. Well, I don't know about service, but they are cloud computing. I don't know, Simon, what's your take on their cloud computing claims?
Well, that's something. It's not just an argument they're making, but it's obviously something the Supreme Court is really worried about because with Supreme Court, their decisions being the law of the land, they realize the implications of their ruling. So in this case, when you were hearing the arguments and their questioning, you could see that they were trying to ask questions in such a way that would allow them to make if they ruled against Aereo in this case, that they could make a very narrow ruling that wouldn't have broad sweeping implications for the rest of the cloud computing industry. In terms of what their argument is that Aereo's argument is that if they are ruled against, then that would have really bad implications for all of cloud computing, from Netflix to Dropbox to Google Drive, that all of a sudden content creators could start, suing companies like Dropbox for containing copywritten content, when really they're just basically storage, working within storage capacity.
Mm-hmm.
I certainly take issue with this argument. I don't know if you have any thoughts.
Well, yeah, I think it actually brings it back to the public performance aspect of it. Although it also overlaps with peer-to-peer sharing a little bit. The tangents that fly off in every direction from every aspect of this topic are a little challenging. So I'll try to stick back to just keep it to what you're saying. That I think the public performance is key here. And if not public performance, then the question of what is the legal status or what is the legal assumption that is made about the content that you have. If I have a file in Dropbox, for example, and I am listening to it and I can share that link with somebody else, there is no like a priori expectation that is illegal content. I may have created it as I've been working on this podcast, in the last few weeks. I've been listening to a file that myself and my, co-host have generated, and we're both listening to that same file, but these are just our files. Aereo, though, does not have even the remotest shred of that claim. They are very publicly pulling down signals that were intended to be put out for free according to the rules for this are very well set. They're 100 years old. The signals go out for free. You can capture them and you can watch them in a private performance for your own personal consumption. A lot of regulation and a lot of laws have set that as being okay. And what Aereo has done is they've said, okay, hey, thanks for that signal. Now we're going to go and turn it into a bunch of private performances, essentially. But that signal, like the rights of that signal, were already well established, and I feel like they're trying to change that.
Mm-hmm. I also think that in terms of the broader implications for cloud computing, there are two kinds of cloud computing companies. There's the Netflixes and the Amazon Primes, in which case they're not just storing content, but they're curating and curating it themselves and actually collecting the content and distributing it. But in those cases, they legally have access to that content. Like Netflix pays hundreds of millions of dollars in licensing fees. Amazon just paid HBO $300 million to get access to their old shows. So there's no legal gray area there, because this ruling, if they ruled against Aereo, wouldn't really, as far as I can see, affect those kinds of companies, because they're already paying they're already doing what the broadcasters want, and they're paying for the content. The other is the simple the cloud computing that is simple storage, like Google Drive, like Dropbox, any other kind of photo or file storage. In that case, they're not really the arbiters of the content itself. They're not the ones who are going and sourcing and finding the content. They're just, you hear this analogy of the parking garage. They're not the car dealership, that are selling cars. They're simply the place that you park your car. So yeah, you could upload content that you downloaded illegally and don't hold the copyright to Dropbox. But Dropbox is just a storage space for it. They're not responsible. And I think, when you're thinking about it, it's not directly related to it might be somewhat the DMCA, the Digital Millennium Copyright Act. But what that act acknowledged was when you're a company that's dealing with millions of users, as long as you act responsibly in the sense of when a copyright holder sends you a takedown request, you cannot be sued by the copyright holder, because you're acting in good faith and are not expected to be able to police millions and millions of users for copyright infringement. So I don't think that this ruling, as long as it's written correctly and narrowly enough, I don't think it would affect the Dropboxes of the world.
Yeah, I mean, it's interesting that essentially Aereo is asking for as wide a ruling as possible. They basically are saying, hey, we're just like those guys, and if you're going to take us down, you got to take them down too. So I saw this interview with Barry Diller where he said that this ruling could be very important for the future of technology. The implication being that they're just like Dropbox, and if you take us down, then so it's basically, it sounds like it's the optics are very bad for them,
Mm-hmm.
and the optics are bad not just for that, but because I was thinking about this. An analogy I just thought of. They are to back up ever so slightly. Like no one really considers peer-to-peer networks cloud computing, although a lot of the same technology is involved there. With files in the in the ether in the cloud. But I think that there is a matter of responsibility around it. So if we're going to go back to two different cases that informed this one would be MGM versus Grokster from the beginning of the 2000s. Grokster was the lesser known but still around version of Napster. They got sued, they lost, and they got. I'm not a lawyer and I didn't study that one closely, but I'm going to go out on a limb here and say that the optics looked really bad for them because they did not look like they were making any effort to protect copyrights. In fact, the opposite essentially was the case. A couple of years later, you had probably the most important case, Supreme Court case that relates to this one, and I believe it's a Supreme Court case, but if I'm wrong on that, don't crucify me. But it was the Cablevision decision. Cablevision essentially got stuck with defending the whole concept of the DVR, and
DVR in the cloud.
Yeah, DVR in the cloud. Okay,
Yeah.
Well, is that all right? So maybe I'm getting that
because DVRs existed way before Cablevision. I mean,
they
way
did.
Before that case. Yeah, and I think there were separate cases that have confirmed, that even came before DVR with the whole can VCR. I'm getting kind of into murky legal ground, but whether VCR should be able to exist and whether we should be able to record a show on a VCR, those rulings helped set the stage for the DVR market in the future and how we knew that it was that was legal. But in case of Cablevision, it was whether these shows could be stored in the cloud.
Okay. I guess I was under the impression that it was the case of just taking that long to get there. Because DVRs first got popular in, the early 2000s when TiVo first came along. So here's what Aereo claims to be. Aereo is like, this is totally wrong. It's like P2P sharing in the cloud with a DVR front end that you see personally. That's totally not accurate, but I don't know.
But the difference
Maybe I should reel that back.
But the difference is Cablevision was paying for the content, so it was really just a case about whether you could store DVR in the cloud. In Aereo, they have more of a two-pronged argument that they have to make, is that they don't have to pay for the content, and they can take that content and just store it on the internet, and just store it in the cloud, even though that they haven't paid for it.
Yeah,
and then,
Cablevision definitely seem to be much better stewards of copyrights.
So I guess one thing I'd like to bring up is this threat from broadcasters. That if this is ruled against them and in Aereo's favor, that they might just pick up their toys and go home and basically stop being public broadcast networks and be only cable subscription services. So it'd be more like AMC, Comedy Central, or HBO, where there's no ambiguity over that you definitely need to pay a licensing fee in order to be able to use their services. So,
specifically, it was Chase Carey, who's the COO of Fox, that said that earlier this year. And I mean, do you think that's a real threat, or do you think it's? What do you think you make of it?
Well, you see this so often in other kind of policy things where companies figure out, like, how can we make these threats that will scare whoever the policymakers are into not making a decision. You saw this a lot with Obamacare, where all these companies were saying, we're going to lay off tons of workers if this is passed because of the employer mandate and trying to force us to have health insurance to everybody. And then, there were several studies within the last year, which is when these layoffs would have had to happen so that they weren't affected by the employer mandate, and they showed that there seemed to be no effect on employment. You see this with minimum wage, where you'll see some CEO saying about how they're going to have to lay off all these workers if this minimum wage bill is passed. But in a lot of cases, these end up being completely empty threats. It costs them nothing to threaten to do this. So it only benefits them to try to scare people to do it. I also
Yeah.
wonder about the viability of it. If only 10% of their revenue is coming from the cable subscription fees,
Right.
and if they were to go to a cable subscription only, it'd be like they're putting a moat around themselves and hoping that the cord cutters don't, eventually
Hmm.
make them obsolete. But also, how much money in advertising are they giving up by not as having wide a distribution through the bunny ears?
It would be not as valuable, I think, is a fair point. Although I do have to say there is 83% cable penetration in the U.S. 7% are relying only on broadcast. I think that what matters less is where they are and who they are. And this may just be a legacy thing, but I don't watch a lot of broadcast television. Sports and Shark Tank are the only things that I watch on broadcast television,
Mm-hmm.
and then I watch Shark Tank half the time on CNBC. So, it's all mixed together. But it does seem to be the case that that would be a big challenge. They would lose money doing that. Another reason that would be really difficult, and I don't understand nearly as well. Well, think about all of the affiliates they have. These broadcast networks have local affiliates, and I know that Chase Carey said that they would work with the affiliates to get them onto cable too, but that just sounds like a bag of hurt.
Yeah, and also how would that affect poor people who can't afford cable? What are kind of these implications? Because the whole point of the broadcast and why they're so tightly regulated is because they're supposed to be for the public good.
Broadcast is already effectively subsidized. I assume that
Yeah, it's basically
you know
free
there would
spectrum.
yeah, precisely. Well, and this is one of the reasons why I think so. Aereo's arguments. First of all, you mentioned cord cutters, and that's I think one of their key cases here. Maybe one of their best, at least optical arguments, is that they are not appealing to to cable users, so they're not threatening the retransmission fees. They are appealing to people who are cord cutters who are not paying any cable fees, therefore not paying any retransmission fees on the broadcast. So hey, cable and broadcast, we're not hurting you. In fact, if anything, we're helping you keep your audience. I get that. I think the logic on that works. I don't think it overcomes other things,
Mm-hmm.
um, right? But the aspect of the spectrum, though, I can say I'm one thing I couldn't quite tell while doing this research here um, was what does Aereo really want to happen? Because think about what happens if they win this case, um, and they do undercut the retransmission fees. Look, if they're giving away this thing for free, why should people continue to pay the same fees? The whole argument behind Aereo is that it costs like 1/10 or less what you pay for cable. Um, so if they're going to do that, then are they not going to? Would they? Do they actually threaten broadcast? Because if they do threaten broadcast, and if broadcast does go to cable, which of course maybe they don't, well then what is Aereo going to capture its signals from? If it wins the way that it seems like it
If
wants to win,
if those broadcasters carry through on their threats.
if they do, right?
One
Yeah,
thing we didn't mention is Aereo is a very localized has a very
right.
localized business model, so it's going to be pulling in through those
Okay.
local affiliates that you're talking about.
So they don't want to go national, or they want to be national, but on an individual basis.
Mm-hmm.
Is that what you're saying?
Yeah, because they're pulling in through the antennas, so they're pulling in through the local broadcast.
Yeah. Well, so I mean, as far as the spectrum goes, which is where I was meaning to go with this, I read an interview with the. So just to be clear, Barry Diller is the financial backing behind Aereo, but the CEO, his name I think is Chet Kanoji or Kanoja. I'm probably getting the last name wrong. So I saw an interview with him, and I read a column by Derek Khanna, who's a libertarian, tech commentator, arguing that hey, if you want to pick up from broadcast and go over to cable, that's terrific. The spectrum you're sitting on is currently could be put to better things. It could be used as unlicensed. I'm definitely not an expert on this area of it, but at least they are contending that that spectrum would be more valuable. It could do things like Wi-Fi and Bluetooth that it wasn't doing before. Which is look, as somebody who is more interested in changing business models and that brought about by technological change. And I'm more interested in that than I'm interested in, the fate of the broadcast networks, which I couldn't necessarily care about. It is intriguing to me.
Mm-hmm.
Um, but I think if you talk about all of that, it's still ignoring the copyright issue, which based on current law, I think that Aereo is probably on the wrong side of.
Well, I guess it goes back to the argument: is should the retransmission fees ever been put in place in the first place? Like, should it before? When you're thinking back to the 1960s and 70s, most of the revenue obviously came from advertising, and should the ethos always been that this is because it's for public consumption and you can get it for free anyway? They should have cable companies should have just been able to basically use it for free, in which case it would just given them more viewers, and then they could have charged more for advertising. And then, ostensibly, if this thing goes through, then they're going to have more viewers who are able to watch it on Aereo and other online streaming services, so they'll have more viewers that they could try to measure and then try to advertise off of. So I guess that's kind of like almost a separate argument: is should these retransmission fees exist? But I don't know, and a lot of the argument is that if they can't do this, then it's killing innovation. But you're seeing amazing innovation with Netflix and Amazon and Hulu, and they're playing completely by the rules, but they're completely disrupting the market and causing mass cable cord cutting. So it shows that you can play by the rules in this case and still succeed.
It is interesting that Aereo is so far off in this direction by itself, whereas Amazon with its Firebox, Apple TV, PlayStation and Xbox have turned into media hubs as well. They are much different, and so this doesn't even get at the that's a whole other topic by itself. We haven't even talked about them until just now. I feel like that's where most of the action is, and Aereo. What is this innovation really? The innovation is. And so I'm going to get back to loophole, which I use, very delicately. So I'll tell you what I think a loophole is. I've already said that I think that it's maybe an unfair judgment. Like a loophole, essentially, is when you have two parties on the opposite side of an agreement, where there is tension between them, and there are external factors that put that equilibrium point where it is. Then if some external factor, such as technology, almost always technology, comes along and moves that equilibrium point, it's the side who is it's the losing party is the one that cries loophole, and it's the winning party that calls it innovation. And I think that's how I started out thinking about this, but then the further I got into it, I'm not sure that this is even really like a legitimate loophole. That's
what it comes down for me is I was reading through all the research for this, is I was trying to find, okay, how is this different from? I kept on going back to what's a show that's on broadcast network that's on Netflix, and I'm pretty sure Scandal's a broadcast show, I kept on thinking, what is the difference between what Netflix does in terms of storing a show in the cloud and giving it to me and charging me $8 a month? And then this company, which is also charging me $8 a month and storing that exact same show in the cloud, but arguing that it doesn't need to pay for it. And I couldn't come up. I couldn't come up with, okay, there's definitely something different between these two companies, other than how they're wording things, like where you're renting the antennas and they're basically getting the content through creating thousands of little tiny antennas and demarcating one for me. I couldn't really come up with too many differences between Netflix and this company, and therefore I kind of came down on the side of the broadcast companies, and as long as we accept the idea of copyrighted content has to be licensed, even when it comes from the broadcast companies, I don't think that there's enough difference between that and Netflix to warrant its loophole.
Yeah, and then when you add to the fact that Aereo is trying to hold the cloud hostage, basically like saying, it's like the bathwater saying, hey, that baby is, crucial to, like, we're the same thing here. Like, no, you can take the baby out of the bathwater and it's just fine. I think that you can you can separate Aereo from the cloud, because just because it's in the cloud doesn't mean that it flies. Napster and Grokster said that.
You're using a lot of metaphors there.
I like my metaphors. If I think of something clever, then I will try to find a way to work it in. Guilty as charged.
What's that famous New Yorker running thing? Block that metaphor.
I don't know that one. That'll be one to bring up on the next. I think it's probably a good place to stop there. We're just getting down to metaphors. Then we should let people go and they can make up their own. So Simon, thanks very much for coming on here.
Oh, thanks for having me.
All right. Thanks, everybody.
All right.